Yes. Okay. Hello, hello. Hello, everybody. I know you're joining, so hope you can hear me. We're going to just wait a few seconds for everybody to join, and we're going to start, okay? Okay, I think we can start now. We're going to start, sharing some information. I know a few people are going to join in the next few minutes, but we want to start because we have an exciting topic today. This is our first CLE of the year. So everybody, welcome and thank you for taking this time to joining us. On behalf of the Florida Bar Tax section, I'd like to welcome you. We also have, let me check if we have, no, we had a special guest, but he's gonna come back later. So I'm gonna introduce him later. Housekeeping matters. The CLE code for today is 5754. I'm gonna share that later in a chat box, so don't worry. As many of you know, if you have questions, please type them in a chat box. Our presenters will answer them as they see them or later at the end of the presentation, okay? So please feel free to write your questions. Also, I'd like to invite everybody who is here to send me a message if you like to present, because we're putting together the CLE calendar and we have some spots still free for you guys to present. I'd love to coordinate that with you. So send me an email. I'll write my email address. It's andrea@thelegacycouncil.com. You already have it. It's been shared in the newsletter, but please just send me an email and we'd like to coordinate that. Okay, let me see. We have, no, he couldn't join. Okay, let's just introduce our presenters. Like I said, we have a great topic today, corporate transparency, examining the proposed FinCEN regulations. And presenting today, we have Jonathan or Jason Warner. Jonathan concentrates his practice on international tax matters. He is a former chair of the Florida Bar Tax section and was named the section's tax attorney of the year in 2008. He was a principal participant in the section's FERTA withholding tax project that resulted in the enactment of a new model federal tax withholding system. He's a past chair of the Committee on International Tax of the ABA section of International Law and Practice, and has authored several comments to Congress and the Treasury on pending federal legislation or regulations. He has been a frequent speaker and writer on international and other tax topics. He received his JD degree in 1971 from Columbia University School of Law, where he was managing editor of the Columbia Journal of Transactional Law. Prior to opening his own practice in 1999, he was a partner in the law firms Greenberg, Turing, Fowler, White, offices in Miami, and Baker & McKenzie. He was an early adopter to telecommunicating, so he works now primarily from North Carolina, from the mountains, he said. Okay, and our next presenter is Scott St. Amand. Scott earned his Bachelor's of Arts in English and Latin from Wake Forest University in 2007. He earned his JD from the University of Richmond, TC Williams School of Law in 2010, and his LLM with honors in taxation from the University of Florida, Levine College of Law in 2016. He is the author of several articles and a frequent speaker on tax topic. Scott joined Fisher, Tosi, Lias, and Ball in 2016, and he concentrates his practice in all areas of tax controversies, both state and federal, as well as state and trust litigation and administration. And without further ado, please, Scott and Jason, take it away.
Thank you, Andrea. Good day, and welcome to our presentation on the Corporate Transparency Act and the recently proposed regulations. I'm going to start with covering the background of the CTA. Scott and I will then trade off coverage of various definitions, effective dates, and deadlines, and things like that. And I'm going to close regarding the impact of the CTA on law firms, some considerations of ethics and security issues, and importantly, thoughts on what's about to come next. That's a lot of important material to cover, and honestly, we may run over time. If you can't stay to the end, please be sure to read the last few slides about what else is coming, that it's worth the price of admission because there is more coming. We hope to have time for questions, but if not, email us and we'll try to answer as best we can. And please see the appendix that you should have received or are receiving now for citations and extra material. So the CTA, despite being enacted over a year ago, the CTA is just now getting public attention from lawyers and others. The one-sentence version is that when final regulations are issued, all new and millions of existing U.S. corporations, LLCs, limited partnerships, and other business entities and some foreign entities are going to be required to file a beneficial owner report and updates with FinCEN, the Treasury's Financial Crimes Enforcement Network, with very, very short deadlines. Now, this is not a public registry, not yet, but don't bet against that in the future. The CTA required FinCEN to issue regulations so that it would, the CTA would be in effect by December 31, 2021. Obviously, they didn't make that. It started last April when FinCEN released a list of questions targeted to the development of regulations, and they received over 200 comments, supportive and critical. The tax section's comments are in the appendix, along with copies or links to others, including the FACT Coalition, the American Bankers Association, and FIBA. But the complexity of this job and the variety of the comments they received caused FinCEN to take 8 months to release proposed regulations, and that was only on part of the CTA. So they obviously missed the proposed effective date. The proposed regs were issued December 7, with comments due this past Monday. And the Florida Bar Tax Section's new comments on the proposed regs are also in your appendix. As I said, I have some doubt whether FinCEN can issue final regulations in 2022, despite the congressional and other pressure they're getting to expedite that. As I hope you're going to glean from our presentation, the issues here are too complex and the impact on small business and law firms is really too severe for FinCEN to rush these regulations at all. By the way, they deferred 2 important rules, database security and access to the database, and coordination and harmonization of the CTA with the Know Your Customer rules or the CDD rules that banks follow. Apparently, when they get around to it, the CDD rules will yield to the CTA rules. Interestingly, in that case, some banks have better information than will be provided under the CTA to FinCEN because they use a lower threshold for beneficial owner, 10% compared to 25%. The banks, by the way, were one of the driving forces behind this legislation. They really want to get out of the very heavy cost burden of the CDD compliance system. Also, at the same time, FinCEN is working on real estate reporting.
You guys hear me?
Excuse me?
Can you guys hear me?
Yeah, they're working on real estate proposal. There was an advance notice of proposed rulemaking issued on December 8, 2021, and the comments on the CTA were due this past Monday. We'll discuss that more later.
You guys hear me?
In addition to the regulations, FinCEN has a technology responsibility. There is going to institute a brand new technology system called BOSS, the Beneficial Ownership Secure System. And that's going to have to take care of the very important security considerations that are in the statute. Even a big question, is it going to be ready? It really can't be fully designed until they've issued all the regulations I've mentioned.
Can you hear me?
and included the revised revision of the CDD rules. Again, I don't see how this is going to be ready in 2022, but they're trying. And they have to get the CTA requirements to be publicized by the various secretaries of state on their websites and through direct notices to existing entities in their state records. And they acknowledged the reporting companies are going to need time. That was very nice of them. So again, I don't see it in 2022, but I could be wrong. If you're wondering where this all came from, it isn't new. It started a very, very long time ago. And there's a broad coalition behind this, not only the banks. Many, like the FACT Coalition, wanted an even harsher program than the CTA represents. Some of you may be old enough to remember the 1984 amendment of the Bank Secrecy Act that required reporting of $10,000 cash deposits. There was a controversy over its application to attorneys and attorney-client privilege that's still not resolved. Some of you are familiar with IRS Form 8300 and Section 6050L. Then the FATF came into being in 1989. It's an international crime, anti-money laundering organization. It's headquartered in Paris. And in 2006, they issued a very critical evaluation of the United States anti-money laundering and counter-terrorist financing program, especially mentioning the unavailability of entity beneficial owner information. And that was followed by the first attempt at the CTA in 2008 with 7 versions since then. And they were all over the place in how they approached the problem. Some tried to put the reporting burden on attorneys or other gatekeepers involved. If you want some more legislative history, take a look at the 2019 version of the CTA. But the 2020 obviously was the one that was finally enacted in a rather rushed circumstance. And all this was likely provoked by a second critical FATF report in 2016 and some recommendations that came out in 2018. The ABA has been in on this for quite a while. They've issued some very substantial protest on prior attempts at imposing gatekeeper obligations or making attorneys classified as financial institutions where they have to file suspicious activity reports on clients and have due diligence procedures and anti-money laundering procedures. This may be payback for something the United States started with FATCA, where we imposed reporting obligations on the entire world because of US tax evasion. At first, there were complaints, but then the OECD realized, hey, this is a good thing. So along came their reporting standard, the Common Reporting Standard in 2014, which the United States decided not to join. But that led to public registries. All of the EU countries now have them, and they're publicly accessible one way or the other with some limitations. Even the tax havens are being pressured to do it. Those should be online and accessible in 2023. Some of these are not very good, but we don't have time to get into that. But there's a site in your appendix to a website that provides transparency scores for various countries. The immediate precursor to this is that a few years ago, the EU started complaining about EU residents and others using US entities with no beneficial ownership information to avoid reporting under the CRS. And US offshore tax initiatives have played a role in this. We've been attacking tax havens since 1981, terminating some of the old great treaties we used to use so easily. We've been involved in FBAR reporting and in offshore enforcement since 2001. And of course, the Panama and Paradise Papers in 2016 and 2017 really helped. Just one last comment before I turn to Scott. The FinCEN focus on malign actors is just amazing. As Scott pointed out in his great article, the proposed regulations mention malign actors 11 times. The regulatory analysis suggests that this is going to involve 25 million filers, 3 million more annually at a $45 average cost. We'll talk about that later. And they're depending on state cooperation, so that may go very well in Delaware, Nevada, Wyoming, and South Dakota. I'm sure most of you can figure out why. Last comment, I'm not a fan of the Heritage Foundation, but if you really want to read a great dissenting viewpoint, there's a site to their testimony before on the Pandora Papers and also their comments to FinCEN in your appendix. I would suggest reading it. It suggests, among other things, that the financial burden is far more than we're hearing, and that we really could get better information if we just use the IRS information with new legislation to allow that to happen. So anyway, I suggest that as some very good reading for background. Scott, if you're ready, please take over with the definitions.
My pleasure. More anonymous companies are formed in the United States each year than anywhere else in the world. And if the internet has taught us anything, anonymity tends to lead to bad behavior. Many, but not all, domestic entities are legally created by filing documents with the Secretary of State or another similar office. To conduct business in the United States, foreign companies must generally register with the Secretary of State or other similar office. Each state has different requirements. Different businesses are required to register, different businesses are required to file. So there's no one size fits all approach, but instead of tailoring the regulations to catch, as Jonathan mentioned, only the malign actors, FinCEN decided that the solution to the impractical situation was to swat a mosquito with a bazooka and cast an exceptionally wide net to catch whatever it could. As we'll discuss, the collateral effects of the CTA and the proposed regulations are quite substantial. So what is a company applicant? This is the first term you need to know. A person, whether an individual or an entity, who files the formation documents of a domestic company or who registers a foreign company with the Secretary of State is a company applicant. However, many companies don't file their own documents. They have corporate agents or even law firms file their documents. So the applicant may be an agent who simply files the document on behalf of the company. And understanding this reality, the CTA proposed that the term company applicant refer both to the principal applicant, the person who directs the filing, as well as the agent applicant, the person who actually makes the filing. Both the direct agent applicant and the indirect principal applicant are company applicants, and they must provide certain information to FinCEN. Obtaining information from both, and I'm quoting here, enables law enforcement to connect the dots between seemingly unrelated companies, owners, and company applicants. Again, the net is broad, the sweep is great. So what must be reported by company applicants? Unless a company is exempt from filing, and we'll talk about that in a bit, it must file a report with FinCEN certifying the identity of the company applicant. We'll call this the CTA report. It's part of the report that Jonathan will talk about later. What must it contain? The company applicant's full legal name, the applicant's date of birth, the applicant's current residential or business street address, and a unique identifying number from an acceptable identification document. But here's the kicker. The number isn't enough. FinCEN wants to see a scan of the actual document from which the number comes from. So why a residential address? FinCEN's belief that it knows where this malign actor lives and resides, eats his frosted flakes in the morning, will help them in the event of investigative need. The term investigative need is nowhere else mentioned in the proposed regulations. It's kind of an amorphous concept of we need the information because we need the information. What is an acceptable identification document? The proposed regulations state that a US or foreign passport, a state-issued driver's license, or any other state-issued identifying document is okay. But providing an identification number is not enough. Similarly, providing a taxpayer identification number, even a social security number, isn't enough. The company applicant must provide a scanned copy of and I'm sorry, I haven't been scrolling. I've been so focused. There we are. All right, I'm back. The company applicant must provide a scanned copy of the identification document. Why an image? Because it will, quote, significantly contribute to the creation of a highly useful database for law enforcement and other authorized users. I can't help but think somewhere the ghost of George Orwell is getting very antsy at this proposal. So what companies must submit a report? An entity is either a reporting company or it's an exempt company. Here we are, reporting companies and exempt companies. There are three categories of reporting companies. There are corporations, limited liability companies, and other entities formed or registered by filing a document with the Secretary of State or equivalent office. A company formed by filing a document is a domestic company. Company registered to do business from outside the US is a foreign reporting company. So if you're taking notes, write this down. When it comes to the Corporate Transparency Act, all roads to FinCEN reporting run through a clerk in the Secretary of State's office, whose name is likely Felicia and whose one joy in life is likely stamping a big red stamp of the document as being filed. All roads lead through the Secretary of State. Say less sarcastically, a company that files a formation or registration document to the Secretary of State is a reporting company. Practically, what does this mean? A reporting company means any entity formed or registered with the Secretary of State. This means that beyond corporations, beyond limited liability companies, the scope is as broad as the state laws require. For instance, certain types of limited partnerships and even business trusts, if under the state law, they're required to file, under FinCEN's proposed regulations, they are likewise caught in the sweep of the net of the Corporate Transparency Act. Because of that, the reporting companies will vary from state to state. Let's see. There are 23 exceptions to the definition of a reporting company. And I won't go through them all, but you'll see a pattern in the ones I do mention. There are security issuers, banks, credit unions, depository institutions, security brokers or dealers, registered investment companies, tax-exempt entities. And there are two outliers, which I'll mention in a second, but all of the first category of companies are heavily regulated already by the United States government. Thus, any information that FinCEN would want from the Corporate Transparency Act already exists. It's already been gathered, filed, collated, color-coded for FinCEN's reading pleasure. In addition to these heavily regulated companies, there are two kind of outliers. There are inactive businesses, which we'll talk about in a second, and large operating companies. Now, to be a large operating company, a company must meet three thresholds. The first threshold being that the entity must employ 20 full-time employees in the US. Second, the company must have filed a tax return with the IRS in the previous year, reporting more than $5 million in gross receipts or sales. Third, the company must operate from a physical office within the United States. So the employee threshold, the gross receipts threshold, and the location threshold. In essence, because of the size and the US presence of the reporting of the company, it doesn't fit this company mold of the shell companies that FinCEN is looking to root out, which mold, I suppose, would look like a shell as well, but it's not the type of company that FinCEN is trying to root out. It's just too big to be hiding this terrorist financing, this money laundering, these malign actors and nefarious deeds. Important to note, and this will be my last point before I hand it off to Jonathan again, with respect to inactive companies or dormant entities, FinCEN notes that the exemption is applicable only to entities that were already in existence by January 1st, 2020, which was 1 year before the Corporate Transparency Act was enacted. So companies that administratively dissolve that were formed after January 1st, 2020, so between January 1st, 2020 and whenever these final regulations are issued, better darn well be sure to let FinCEN know that they no longer exist, or they may get tagged with penalties for failing to inform FinCEN of their, at this point, non-existence. So with that, I'll turn it back over to Jonathan.
Thank you, Scott. Now we turn to another core CTA definition, the beneficial owner of a reporting company, which is the core information they wanted to get. The relevant statutory language is on your screen at slide 24. And first note that it means, with respect to a reporting entity, any individual who directly or indirectly, through any contract, arrangement, etc., exercises substantial control over the entity or owns or controls not less than 25% of the ownership interest. The CTA does not define substantial control directly or indirectly or ownership interest. Note how broad this is. And note also the 25% test. As I mentioned, some banks use 10% and some transparency advocates wanted that to be the standard. The CTA disjunctive definition and the broad definition of substantial control, which we'll turn to in a moment, can result in naming several persons as a beneficial owner. The CTA intentionally did not follow the existing CDD rule that required you to disclose only one individual that had a significant degree of control over the entity. The reason why is that they felt that while banks could make a qualitative decision who should be identified for that purpose out of multiple candidates within an entity, FinCEN didn't think that would work on a broad-scale national basis, being interpreted by a broader spectrum of persons without training or experience, and thus greater room for error. FinCEN, however, is, I think, indirectly adopting the effective control concept within these rules that was so heavily criticized when it was developing the CDD regs. Now, the FinCEN material says that they expect that the substantial control test will result in the identification of at least one beneficial owner, even if everyone is below 25%, whether through widespread ownership or an exception that Scott covered for a reporting company. There's some exceptions here. The proposed regs, this is slide 26 if you're following, do not include a minor child if parent or guardian information is reported. They don't include a nominee or a custodian or an agent. They don't include a person acting solely as an employee of the reporting company. But FinCEN added the language, not as a senior officer. Senior officers are really reportable people. And they do not include, the slide 27, an individual whose only interest in the reporting company is through a right of inheritance. There was some confusion, and they've clarified here they mean in the future. They don't mean somebody who inherited their present ownership of the company, which some people were maintaining. And lastly, an exception for creditors, but it is you need to work through it carefully. If the creditor has only a right to a payment of a predetermined sum of money plus interest without any other hallmarks of beneficial ownership, then that creditor is exempt. But if there's anything else, then they're caught as to be named as a possible beneficial owner. It's clear that under this definition, shared appreciation mortgages and equity kickers are a problem. But what about a variable interest rate instrument pegged to financial performance metrics? There's no answer to that yet. Okay, moving on, slide 28. FinCEN also went very broad in defining an ownership interest. The part I find interesting here is B. As if you read the statute carefully and the accompanying Anti-Money Laundering Act, you realize that FinCEN did not include general partnerships and trust as reporting companies, at least not now. That's under study. But here, in terms of an ownership interest, there's a reference to a capital profit interest in a limited liability company or partnership, including limited and general partnership interest. I think the best reading is that's a reference to a limited partnership. Others are thinking, oh, well, gee, they're looking to include partnerships in a backdoor method. Well, there's other things you need to look at in terms of ownership interest. They're in the slide. And now we get to where they dealt with trust, the definition of directly or indirectly. They don't really define, they give examples, and mostly what you expect. But here again, they try to address trust despite the difficulty that they know. When they did the CDD rules, FinCEN acknowledged that it was really not possible to identify a beneficial owner among the various parties to a trust, the settlor, the trustee, the protector, the investment advisor. So that's the CDD rule just references the trustee. And there's more that's not really in the regs yet. FATF, I mentioned earlier, is raising the question, what if a company in the ownership of a reporting company is acting as a trustee? I assume they mean a trust company. They didn't clarify. Their answer is to look at the trust document. They're assuming that trust law imputes beneficial ownership of the trust. And that can be really debated. And also, I get a little nervous when FinCEN is talking about defining trust. If you've ever looked at their horrid definition of a U.S. trust in the FBAR regs. Another question here, is FinCEN toying with attribution? We don't think they should go down that road. You know how much we have to deal with attribution rules in the code and regs. And one final comment on this, the tiered ownership rules are still unclear. The American bankers and others chimed in. What about a waterfall arrangement in a reporting entity that varies, where ownership varies over time based on net cash distributions? No idea how to handle that. And there's an aggregation rule, which you look at every form of interest in determining the 25% ownership rule. Now we're getting to substantial ownership, which includes service as a senior officer, authority over the appointment or removal of a senior officer, direction, control, decision of substantial influence over important matters, which are listed in A through G here on slide 31, and the catch-all, any other form of substantial control. They're trying to catch de jure on de facto authority. And they're clear in the preamble of the regs that day-to-day managerial decisions, say for a part of a reporting company's assets or employees, for example, does not make that decision maker in substantial control by itself, unless it meets another element of the criteria. They rejected a per se rule requiring listing all officers, focusing on just senior officers. Moving on to slide 32, they give a definition of directly and indirectly exercising substantial control. So it applies there as well as in ownership. They assume that the reporting company, again, will have to identify at least one beneficial owner under the substantial control prong, regardless of whether that individual otherwise satisfies ownership. And you have to report every individual meeting the definition, not just one. FinCEN recognizes that there'll be additional costs because they're requiring more than the CDD rule, but they expect that to be minimal. They think it's easier to report all BOs beneficial owners rather than just decide on one. And because you're revealing a lot of information that's maybe not otherwise public. FinCEN says, we don't care. It's not public information, so just report. This is going to be difficult enough to deal with a domestic company, but when you get a foreign entity as a reporting company or an ownership, there are going to be some really interesting questions. How do you classify a GmbH or an installed? And remember, you can't use the check the box rules. They didn't get imported into here. You are a check the box election. We may be reverting to the old Kittner regs that those of you with less than 15 years of practice experience don't have any background with. So you're going to enjoy relearning those. And in foreign countries, we get to issues like with unfamiliar concepts of ownership, like usufruct or a pending interest in family property under various foreign forms of community ownership and forced heirship. So this is going to be some quite interesting distinctions being wrestled with between law firms and clients. Scott covered what's needed to be revealed, so I'll skip that. There's a special rule if a beneficial owner dies. Of course, they cease to be a beneficial owner immediately, but the reporting company doesn't have to notify FinCEN until the estate is settled, and then you update the documentation. We don't know what kind of reporting form they're going to use. I'm on slide 35 if you're following. Some people have suggested using a modified form of the CDD form because it's simple and available. The site here on the slide, for some reason, just doesn't work. It's accurate, but it doesn't work. But it's easy to find a copy of that form on the FinCEN website. Scott, I think you mentioned the FinCEN identifier, so I won't dwell on that. I just will say, if the final regs don't provide relief to law firms as applicants, start applying as soon as FinCEN is ready. It's going to be a lot better to use the FinCEN identifier than providing required information to hundreds, if not thousands of clients, if you've had an active corporate practice in your background. Comment here about tax residency, final, and I'll turn it back to Scott. Unfortunately, that use of the street address for tax residency purposes raises all kinds of issues that a lot of us are familiar with, dealing with foreign individuals who may have an income tax residency here and a domicile in another country, multiple residential residences all over the world. And what do you determine? Which is their tax residency? Are they trying to bring in a new concept here? Foreign individuals living here on temporary visas like student visas. How do we handle that? Foreign individuals are often confused by the reference on immigration forms of others about where you have a residence. This is not going to help. But they may be claiming, yeah, they have a residence in the US, but have a closer connection with the foreign country, or taking a treaty position that their center of vital interest is with the treaty country. This has got to be changed. Hopefully comments to that effect will be listened to by FinCEN. With that, Scott, back to you.
Thank you, Jason. So we come to the question of, so you have to file it. When do you have to file it? And for new companies, the answer is simple. The reporting company, if it's formed after the effective date of the final regulations, and remember, what we're talking about right now are only the proposed regulations with comments due on last Monday or this Monday. But when the final regulations come out and are published, that's the deadline. That is when you cross go and have to start reporting. Whether FinCEN will actually enforce that, whether there'll be a grace period, there are all kinds of questions into how they are going to be able to reconcile the deadline that's in the Corporate Transparency Act, which says when the final regulations are published, you must report, with the practicality of actually reporting when the final regulations are published. So whether that's a delay in publishing or whether it's some language built in, we don't know. But once the final regulations are published, the report must be filed within 14 days, 14 calendar days after the formation documents were filed with the Secretary of State. If a company was previously exempt, but through some change in corporate ownership or corporate formation is no longer exempt, then the company must file the report within 30 days after it loses exempt status. Ironically, if a previously non-exempt company later becomes exempt, even though an exempt company has no reporting obligation, the now exempt company must report that it is no longer not exempt. And the FinCEN regs spend pages justifying this. It's absurd. It's really what it comes down to. So exempt companies who are no longer exempt, 30 days, new companies, 14 days after they file creation, formation documents, or registration documents. The most troublesome impact of the CTA is not the proactive effect, but what happens with the millions of companies that have been formed prior to the effective date of the final regulations that were operating before beneficial ownership information reporting was even a glint in Congress's collective eye. Again, if you're keeping score at home, write this down. Companies that are already in existence must also file a CTA report. There is no grandfathering clause, language, phraseology, anything in the CTA or the proposed regulations that would exempt existing companies unless they are otherwise exempt. So Cousin Jim Bob's Lawnmower Company that's been operating for 20 years has to file a CTA report. Existing companies have 1 year, just 1 year from the effective date of the regulations to file. Again, that's as it stands right now. We'll see what ends up happening. But another thing should be noted in the Corporate Transparency Act, it says that the company shall timely file. Well, FinCEN took timely down to 30 days for the exempt companies. And 1 year is just a very short period of time for FinCEN to put all of their, to get all of their ducks in a row. So let me catch up. I apologize for being dilatory on my slides. With 1 year, this creates a practical and logistical nightmare, not only for FinCEN, as Jason was saying, to get all of their ducks in a row, but for law firms, corporate agency companies, all of these, just to inform everybody, much less make the filings, but inform everybody. As I was writing my article, that image of Kevin Bacon at the end of Animal House, standing in the parade, raising his hands, yelling, "Remain calm, all is well." I think that's what FinCEN is going to be doing once these regs are published, because it's going to cause panic. And if it doesn't cause panic, you're not paying attention. Exempt companies, as I mentioned, that lose their exemption have 30 days. As Jason mentioned, when a beneficial owner dies, a report must be filed within 30 days after the estate is settled and new beneficial owners are put in place. Any other changes, and the regs don't really define what other changes might be, which leads to even more confusion, must be filed on a report within 30 calendar days after the date in which there was a reportable change. So now we get to the even scarier part, which was, well, actually, before I get to the violations, there is a glimmer of hope, small though it might be. There is a safe harbor built into the regulations and the Corporate Transparency Act. If a company applicant has filed inaccurate information with FinCEN, but corrects it voluntarily and within 14 days, calendar days, after the company learns or has reason to know that any required information was inaccurate. If the company learns a year later that the information was inaccurate, that's not enough, because FinCEN also says you have 14 days from when you learn, but in no event longer than 90 days. So there is a 90-day threshold for correcting information, even if there's no actual knowledge of misinformation reported to FinCEN. So what are the consequences for reporting violations? Well, there are two. Like the FBAR regs, there is a willful violation and a non-willful violation. A willful violation includes providing false or fraudulent beneficial ownership information or failing to report or update FinCEN with complete beneficial ownership information. I raised this in my article, but it should be noted, the broad application of this seems to suggest something akin to the trust fund recovery responsible penalty or responsible person liability. The penalties apply not only to the individual reporting the false or fraudulent information, but also to the person who directs or controls the filer or who controls the company. So as with the trust fund recovery penalty under Code Section 6672, an individual who has control over someone or could have controlled the reporting of the information is equally liable for either a willful or a non-willful penalty. And again, when we talk about person in the context of the CTA, we're talking about individuals, reporting companies, and entities. Indirect liability, I just discussed with my analogy to the trust fund recovery penalty. And also with respect to indirect liability, a person can violate the CTA indirectly by providing false information to another person who then reports the information. It's like a game of telephone. If employee A tells employee B something false and employee B then files a CTA report, employee A is equally liable for a willful or non-willful penalty. It's exceptionally broad application. Again, FinCEN justifies it as it's necessary to deterring malign actors who may not otherwise be deterred. But the civil penalties are up to $500 a day that the violation continues, but there is no ceiling. So these penalties can continue ad infinitum. And that should be scary to you. It's scary to me. Criminal penalties up to $10,000 per violation and up to 2 years and a trip to the Hooskow. The penalties are not something that should be toyed with, which makes complying and helping your clients comply that much more important. So with that, I will turn it back over to Jonathan to talk about the impacts on law firms.
Well, Scott, thank you. And I will hopefully FinCEN, when it sends out the information packages, will follow the lead of the Hitchhiker's Guide and put the words "Don't panic" on the cover. So anyway, okay, the first thing that the law firm is going to notice, I think, is that they will themselves be a reporting company. There's an exemption for registered public accounting firms, but no exemption for attorneys or firms. So not only are you going to have to disclose beneficial ownership of the firm, you're going to have to deal within that of the issue of substantial control. With memories of 3 large law firms in my background, I can imagine some beautiful discussions going on behind closed doors as to who is or is not in substantial control of that firm. Hopefully, FinCEN will add law firms to the list of exemptions, but that requires concurrence not only of the Treasury, but the Attorney General's Office and Homeland Security, that we're innocent, innocuous, and of no use in national security, intelligence, or law enforcement. So I don't know if that's actually going to help. And you may be shaking your head right now, but there are people, including members of Congress and one from Miami that you might not be aware of, who do not think highly of lawyers or law firms and really have no qualms about casting public aspersions on lawyers. So the CTA is just becoming known right now to professionals and to small business. The next big problem for law firms is going to be identifying current and former clients, because you want to alert them. You're not going to not do that with the filing requirement coming. This is going to be, a little easier for new entities. You advise or warn them at the time. But can you imagine what some of the older law firms face with no grandfathering rule? And are records available for this? Some firms purge or shred their records after 6 years, depending on the particular state law. And is your client database up to date? I learned recently one small firm practitioner with a great idea. He sends out tons of printed holiday or birthday cards just to get returns of bad addresses for his clients that he can update. Smart guy. So even worse, by the way, than dealing with the incorporated issue is tracking down the attorneys or staff who would have been the incorporators. And if you can, you want those people to apply right away for a FinCEN identifier as soon as that's available. Otherwise, they're going to be producing a lot of date of birth and address and photo ID information for reporting company clients. There's an exception for a reporting company created before the effective date of the regs, whenever that's going to be, if the applicant dies before that proposed one-year reporting deadline by FinCEN. In that case, the reporting company puts down whatever it has actual knowledge of and doesn't have to go further. The other thing that the law firm is going to really have to deal with is the definition of applicant includes a supervisor. That's any individual, as Scott has started saying, who directs or controls the filing of incorporation or formation documents by anyone else. That's hard to determine even for recent formations. What kind of records do you have that will allow that to be determined? And you may have to locate an old supervisor. And there may be a lot more than one supervisor in a particular case. It's good that CTA follows the example of instructed by the ABA a few years back of imposing the reporting obligation on a reporting company and not on the attorney or law firm that formed the entity. Believe me, there are people out there who want to do that, and that's going to be revisited time and again in the future if you'll wait to the end of this presentation, even if we run over a bit. So this right now, we're avoiding the ethical issues raised by the prior gatekeeper approach, which have been heavily debated. But that the ABA Ethical Rule 1.6 and the Florida Rules of Professional Conduct 4.16 are not particularly relevant at the moment, although other states may vary. There are summaries of these cited ethics rules and opinions in your appendix. If you're, however, going to assist a client in compliance, then further ethical issues can arise. And you need to start reviewing your engagement letter to make sure you're really clearly depicting who's the client. Is it the reporting company, or is it that powerful beneficial owner who you represent in other things? You're going to need the beneficial owner's consent to disclose information and his cooperation or her cooperation. And remember, there could be multiple parties. What if one of them says, no, I'm not reporting? What does the reporting company do? That's not clear from the regs. More importantly, if you start getting the hint from the client that I'm not saying that, we're going to have to deal with this, you are then in an ethical situation. Under the ABA Rule 1.2D, you're required to avoid counseling or assisting in a crime or fraud in non-litigation settings. That's permissive. Florida Rule 4.16 says an attorney must reveal confidential information to the extent that the lawyer reasonably believes necessary to prevent a client from committing a crime. And of course, other states may differ. But all these are clear. You have to avoid counseling or assisting in a client or fraud. Ethical rules really give us no meaningful guidance. They tell us some things we can't do. What do we do affirmatively? They suggest due diligence. There's an ethics opinion, voluntary good practices guidance, and those are in the sites in the appendix. Or you got to resign or terminate representation, Rule 1.16 and Florida Rule 4.1.16. Now, if the only hesitation is that of interpreting a beneficial ownership rule or an exemption, separate counsel may be an answer for that. But you're still going to have to provide applicant and supervisor information to the reporting company. And you've got to deal with all these things within the 14-day time limit for filing for new entities. Some law firms have decided to hold off forming new entities until the final regs were issued. Maybe they don't realize how long I think that's going to be. Others say they're no longer going to act as incorporators, but how practical is that? Some are suggesting getting client identification in an engagement letter for inaccuracies in beneficial ownership information provided by the client if the law firm is assisting. There's an alarming statement in the preamble to the proposed regs that's highlighted on slide 54. It seems to be suggesting that law firms, as a defined company applicant, have responsibility for accuracy, and that just can't be. It's probably a holdover, and somebody had noticed from a prior version of the CTA. It's being pointed out to FinCEN. Hopefully they will disclaim that intent in the final regs. Other issues with ethics, besides updating your engagement letters to alert clients to the CTA and being clear who is the client, you ought to disclaim any obligation to assist with filing a CTA report unless specifically engaged. That would include dealing with beneficial owner information. You also should be clear about when representation ends, and you might want to advise about issues with the potential security of the FinCEN database and anticipated access by a lot more people than you might think. And by the way, for the law firm now obtaining confidential client information they might not already have, how secure is the law firm's database? And what if you discover in the course of all this that true ownership contradicts prior information from the client that the law firm may have acted on, perhaps in the prior material filing and negotiation, somehow used in prior representation? There really are no answers here. I've mentioned that if you have multiple owners in a reporting company, what if somebody balks? What do you do? Well, no guidance. You might want to try and look at future shareholder agreements, anticipating CTA reports and having a contractual obligation to cooperate among shareholders. But that's not going to cover those with substantial control if they're not shareholders, or certain creditors or indirect owners. Okay, we're off ethics and onto compliance costs, slide 57. FinCEN thinks it's only going to cost an average of $45 per reporting company, which includes applying for the FinCEN identifier. I do have to say how ridiculous that is. 70 minutes of response time. Anyway, there's going to be huge funding for this effort. There already is. But besides what we discussed about the Heritage Foundation's estimates of much higher costs than we're being led to believe, the IT cost alone in preparing for this is going to be $33 million plus $31 million a year. And that doesn't include the cost of administering access to the index and enforcing compliance. I mentioned deferred regulations. This is now we're in more to come territory. The CDD rules will have to be coordinated soon with the CTA rules once those are ready to be final. Good job. Hopefully, FinCEN will do a good job there, but the banks really want out of the FinCEN burden. They want to be able to access the registry, which they surely will. They want to be able to rely on it, but they don't want to be required to do so or to rely on it. They will keep their own records. And database security is going to be very interesting. Can't wait to see the forms and procedures. And FIBA's comments about foreign access are worrisome. FIBA made some very good comments, which are cited in your appendix, about whether they should be using existing treaty mechanisms to exchange information rather than what's contemplated in the CTA about requests coming in from foreign sources. Okay, implementation, they've got a lot to do. They've got to get the technology ready for the reporting. They've got to develop the reporting form. They have to provide for verification, which will involve additional requirements and cost. They've got to get the FinCEN identifier up and running. Are they really up for this? It's a small agency. They've got 300 employees. Most of them, I would guess, that come from an enforcement background, not a business or corporate background. And what about training new employees? Are they going to hire people who are better suited for handling business issues or just enforcement people? If the latter, then I think we're all going to have a lot of problems. They know time's needed. They know they're going to be cost to the states, whose cooperation is critical. They were funded with $136 million for fiscal year 2021, which obviously they didn't earn because they were so late, and $60 and $35 million for each of the following 2 years, and more money to carry out the section including authorizing funds to the states, but only if the states cooperate in promoting awareness and compliance with the CDD. How are they going to verify? Well, it's an important issue. There's a lot of criticism of some of the EU and particularly the UK database that the verification procedures are very weak and not very good. FinCEN is being encouraged to look at automated tools with some human intervention to look for on a risk-sensitive basis without requiring expensive and burdensome verification procedures. There's a hint that reporting companies are going to be required to affirmatively and periodically confirm the continuing accuracy of their prior reports, thereby leading to a fresh violation if they don't do it right. Okay, starting on slide 63, and I know we're beginning to run over, there's a list of studies that are required by the CTA, and more importantly by AMLA. Look in the text of the NDAA beyond the CTA itself to the AMLA section 6502, where there's continuous review of exemptions being required and requiring a study of whether we need beneficial ownership information for partnerships and trust. Yes, they are really looking at that. They'll have to report on whether that lack of information has impeded investigations and look at the continuing international criticism of the CTA and our failure to provide so far meaningful beneficial information. That's going to be very, very interesting. I will mention one other. At the very bottom of slide 63, there's a reference to a GAA report. You want to read it to understand how little they think of us as lawyers. You might also, while you're doing that, I'm going to skip ahead over the real estate transaction regs because I mentioned that just to say, when those come out, I envision a nationwide GTO requirement with minimal dollar thresholds, including finance transactions, not just cash, commercial as well as residential and permanent. On slide 65, there's a mention of the Enablers Act. You want to read that, and if you can, the press release from Representative Wilson, a Republican from South Carolina, who stated bluntly that aspersions on U.S. enablers of kleptocracy, the unscrupulous lawyers, accountants, and others that allegedly failed to conduct adequate due diligence in international transactions. The co-sponsors include Maria Salazar from Miami. That was a shock to me. So yeah, they don't like us, and we very likely aren't going to be exempt, and we're going to have a lot of issues over the years. And finally, let me just say that I'm worried about the security of the FinCEN database, no matter what they say. Treasury's been hacked, the IRS has been hacked, new tools are coming out every day, leaks and whistleblowers may be a problem, and we're going to be sharing with foreign countries without adequate safeguards. So yeah, I have some concerns here. And so basically, caution is the word of the day, if not panic. So hopefully I haven't spoken too fast. We tried to get it in on time and we came close. I don't see any new questions here. We had a couple that we've answered directly, and they weren't worth for the whole group. So that's it for the day. I hope we've made things better for you with the brave new world coming. Thank you.
No, thank you. Thank you both. Thank you, Scott and Jason. You share, great information today. A few people had to leave, but don't worry. We're going to share the recording. Thank you all. I think somebody posted a question about the CLE code. It's 5754. We are going to share information of our upcoming CLE, so stay tuned. And I guess that's it for today. Thank you so much.
Thank you. Enjoyed it.
Bye. Enjoy your day. Bye, Scott. Thank you.